Well, good morning and welcome from Midland, Michigan to this virtual town hall brought to you by the Mackinac Center. Today we're going to be discussing a topic that is of great interest to a lot of folks in Michigan right now, but is based on laws that are decades old. And we'll be talking about gubernatorial emergency powers and what governors can do in the state of emergency, with states of emergency, and in times of crisis, and how they have to work with other branches of government. My name is Mike Wrights. I'm the Executive Vice President of the Mackinac Center, and I'll be moderating this event today. I'll be here with several colleagues from the Mackinac Center. And our format today will be pretty simple. We'll have some opening remarks, and then we'll have remarks from each of our panelists and a little bit of Q&A that I'll moderate to begin with. But then we really want to get to questions from participants that are watching this program live. So if you're interested in putting a question in front of any of our speakers today, please do so. And you can do so by typing your question into the Q&A box. I'll be reading those to our panelists toward the end of the program. And I will try to get to as many of those as we can in the limited amount of time that we have. So to set the stage for this entire conversation, I want to mention just a couple of things. On March 10, the state determined that we had our first two cases of the coronavirus here in Michigan. And on that same day, Governor Whitmer declared a state of emergency for the entire state, and then began to take a series of actions that lead us to where we are today. On March 13, the governor restricted large events and gatherings of people. On March 16, the governor closed theaters and bars and restaurants, although restaurants could still operate with takeout offerings. And then on March 23, the governor issued the first stay-home order that affected the whole state and then has been extended a number of times. So to date, the governor has issued 113 executive orders related to COVID-19 and the state's management of that crisis. And along with those 113 orders, we have about 977 frequently asked questions that the governor has posted on her website, which means we've got an enormous amount of guidance coming from the executive office on what people and businesses are supposed to do in this time of crisis. Now, not surprisingly, the governor's actions have triggered some backlash. There's been backlash and outcry from the public with a number of gatherings and protests that started in early April. It's triggered a conflict with the legislative branch, and that conflict has actually ended up in court. We'll be talking about that a little bit today. And a number of governor's orders have been challenged in court. So one of the questions at the Mackinac Center that we heard early and often was, well, what is the governor allowed to do? And can she do what she's doing today? And so we're here to talk about that question today, and we have three people to address that question and other questions. So first up, we'll hear from Joe Lehman. Joe is the president of the Mackinac Center and has been with the center since 1995, was named the president in 2008, and has a number of things to address about our activities. Next, we'll hear from Michael Van Beek, who's our Director of Research. He's been with the Mackinac Center since 2009 and oversees all the production of our research products, short form and long form. And then finally, we'll hear from Patrick Wright, who is the Vice President for Legal Affairs with the Mackinac Center, and he runs the Mackinac Center's Legal Foundation and oversees litigation and amicus briefs and legal research here at the center. So first up, we're going to hear from Joe Lehman, and Joe, I'll hand it over to you.
Right, thank you, and I want to thank everybody who's tuned into the program today. We have a large RSVP list, and I want to especially thank Mackinac Center supporters who have maintained their support during this time. and given us lots of encouraging words. And others who tune in today are just interested in policy. But just a little update on how the Mackinac Center is doing. I've been asked that question more in the last few months than ever before. We're weathering the various crises well. We have the COVID crisis. We have the economic collapse triggered by the lockdown in response to COVID. We've had a flood in Michigan that was devastating and forced the evacuation of 11,000 people. And 3 Mackinac Center employees had pretty significant damage, but thankfully no one was hurt. And of course, we've had protests even in Midland, Michigan, related to the death of George Floyd. You're all aware of protests going on around the country. In Midland, the protest was large but completely peaceful and caused no problem. We've met these challenges with strong reserves that you've helped us with, and a clear mission and a great team of nearly 40 people. We're even having a pretty normal intern program this summer, I'm very glad to say. So today's program on emergency powers made me think of a fascinating book, which I would recommend to all of you. It's Crisis and Leviathan by Robert Higgs. And his subtitle is Critical Episodes in the Growth of American Government. And his thesis is when crises come, governments expand their powers and they seldom contract. Those powers seldom contract to where they were before the crisis. And so that gives us at the Mackinac Center some direction for how to proceed. We have been able to achieve some good reforms related to the COVID crisis. Most of those good ones came very early in the crisis, where the governor actually implemented some of our suggestions, things like liberalization of medical licensure laws and things of that nature. Sadly, she's already rescinded some of the emergency or some of the executive orders that accomplish some good things. But we want to lock in some of the good stuff and keep some of the bad stuff temporary, the various restrictions on society. And meanwhile, while these things are going on, we look for opportunities. And one opportunity may be in the form of a massive new opening in educational choice. We're waiting any day now to hear from the United States Supreme Court on its decision in the Espinoza case, which could really open up education opportunities across the country, including in Michigan. And U.S. Secretary of Education Betsy DeVos is working very hard to create some sort of new federal scholarship that could be used for choice in the states. Federal involvement in education is problematic in its own way, but choice is good, and so nobody gets everything they want in a political compromise. But I will turn it back to Mike Wrights now, who will introduce or who will then proceed to guide the rest of the program on the governor's emergency powers. Thank you very much.
Okay, well, let's dig into this. Thank you, Joe. And just as a reminder for all of our viewers this morning, if you have a question, we want to try to answer your question. And so you can fill out your question in the Q&A box on this program. Go ahead and type it in whenever a question occurs to you, and I'll be reviewing those throughout the program. And then toward the end of the conversation, we'll be able to get to a number of those questions. So first up, Mike Van Beek, I wonder if you can give us an overview of how these emergency laws came into place and how they interact, or how the governor interacts with them in the situation of an emergency, and what's the state of play for emergency laws in Michigan?
The governor has a list of frequently asked questions on our website. but I don't think it's accurate, or at least not. It's not really a catalog of the most frequently asked questions, because the most frequently asked question to me has always been, is this even possible? How is the governor able to do all of these things? And that's in order to answer that question, you have to go back into the history of Michigan law and look there. And this is really a truly unprecedented time. This is by far the longest declared state of emergency in Michigan's history. And there are two laws that guide the powers that the governor can use in emergencies. It's important to remember that these are not constitutional provisions. The Constitution, Michigan Constitution, only mentions emergencies in relation to wartime situations. So there are the powers that the governor has are strictly in statute. And one of the laws is the Emergency Powers of Governor law that was passed in 1945. And the other one is called the Emergency Management Act, which was passed in 1976. And really, one of the things that we've experienced so far in the midst of this emergency is that not a lot of people know how these laws work, and many of us were sort of shocked to see how these were implemented. It's fortunately at the Mackinac Center we have a long bench of experienced researchers and experts. So I was able to draw on them and some of the other research that I've been able to do historically. People like Richard McClellan has been helpful to me, who's on our board and who's at this event today. So welcome, Richard, and thank you for your help. But I wanted to give you a brief, real quick historical view of how these laws came to be. The Public Act 302 of 1945 was created in response to a riot in Detroit in 1943. It was asked for by the Michigan State Police. It was basically their idea to create a policy that allowed the governor to declare an emergency over a particular area and then allow policies to have the force of law over that area. And this was debated in the legislature, and one of the arguments for it was that it would allow the state to avoid martial law, which is where all civil rights are suspended and the state basically uses its full police power over the populace. So the idea was let's create a process whereby the governor can avoid martial law, create executive orders that have the force of law, and then use that as a way to help minimize the damage from rioting and other disasters. There are important omissions in the 1945 law now that we understand are important. It does not have any mention of legislative intent. In fact, the intent is very clear that it allows the governor very broad powers, but there's no role for the legislature that is mentioned. There's no process mentioned for extensions or renewals of emergencies, or there's no mention of a limit to the length of the emergency that can be used. And this law has been rarely used throughout Michigan's history. The governor who used it the most was Governor George Romney, and he experienced a very large labor strike in Hillsdale, Michigan in the 60s, and then also riots again in Detroit in 67, and then in 68 after the assassination of Martin Luther King Jr., and he declared emergencies in all three of those cases. Now, over time, eventually we got a new law enacted that is the Emergency Management Act of 1976, and this was a replacement for a 1953 act, which was about civil defense. And civil defense was a program that was created by the federal government, basically in response to the Red Scare and the Cold War. And the idea was, if we ever were under Soviet attack, we would have a way for the local governments, state governments to be prepared. So in 76, we modified that civil defense bill and created a act which about half of it is dedicated to that local coordination of state powers and state resources and state emergency response teams and those sorts of things. And the other half is dedicated to allowing the governor to declare a state of disaster for the entire state. But it has a different process for how that works than the 45 Act. So the way this works in the 76 Act is that the governor can declare a statewide emergency, but it only can last for 28 days. After 28 days, it either ends or it can be extended if the legislature approves. Like the 45 Act, every executive order issued is temporary. It expires when the emergency is over. And it also includes a protection for citizens, in my view, in that any violation of these orders is only a misdemeanor. So that sounds harsh, that if you violate if you don't wear a mask, it could be a misdemeanor potentially. But on the same side of things, it's also a protection in that the governor can't make it a felony to violate one of these orders. This act, the 1976 Act, is used regularly. It is the most common way that the state has issued emergencies, most in response to natural disasters. Governor Granholm used it extensively, and Governor Whitmer has used it just last year. She used it 6 or 7 times. So it is the most commonly used act. Now, the conflict is that arises because Governor Whitmer believes that she can use the 1945 Act to declare a statewide emergency and then unilaterally determine when an emergency begins and ends. Therefore, under her interpretation, governors may make use of these extra legal powers at any time of their choosing and for however long they choose. And so that is the source of the conflict. And based on the research that I've done so far, this is the first time in the state's history that a governor has attempted to use this emergency power law in this way. No other governor has attempted to unilaterally determine when an emergency begins and ends longer than the 28-day limit that is in the 76 Act. With that, we can talk more about this conflict, which obviously is the source of many of the lawsuits that we have ongoing with the governor.
About litigation, Patrick, and I want to ask you a couple questions. One, I think you're likely to have gotten this question from people. I know I have. And the question is, well, what does the Michigan Constitution say about all this? Mike mentioned a little bit about that, but I wonder if you could dig into that as well. And then could you address the variety of litigation that's out there right now? My last count, when looking at the count from the team, was that there are 22 different lawsuits that have been filed against the emergency actions the governor has taken to address the COVID-19 emergency. And so what are those lawsuits about? What are they addressing? What are the claims? And which court is most likely to resolve the issue at the end of the day?
Fairly silent on this question. When the governor does her executive orders, she occasionally will cite the portion of the Constitution that says there is a governor in Michigan, and therefore she implies that there are powers to do all of these various actions that she has taken under the 2 statutes. There's nothing in the Constitutional Convention notes that supports this. So to the extent that this is allowed, it is allowed if the legislature had the power to do this in the first place and could delegate it to the executive through these 2 acts. And that's what a lot of the litigation is centering on. There's 2 or 3 different major types of claims, and there's 2 different court systems. Obviously, there's a state court system and there's a federal court system. In either system right now, you can bring both state law and federal law claims. So what has happened is that the various and sundry people that have made these challenges have had to decide, okay, what court system works best for the claims that we are trying to make. I would group the types of claims as state law claims and federal law claims. The federal law claims are all constitutional. These are all questions of whether or not these various actions that are being taken violate the federal Constitution. The state law claims break down into two separate categories, and those are state constitutional claims, which are often very similar to the federal constitutional claims, and then these statutory interpretation claims over what the 1945 and 1976 Act allow. So you've gotten a number of these cases filed in federal court related to this, and those would generally be more towards the federal constitutional things, but you're allowed to append state claims to them. Probably the third question you ask is what court is most likely to decide this? The court where we're probably going to get the most authoritative decision out of is going to be the Michigan Supreme Court. And what's going to happen is what's happened in one of our two cases that we have filed to date, is that when you file state law claims in federal court and it's new and if it's undecided and if it's close, what they'll do is they will certify a question to the Michigan Supreme Court. And so we had filed a suit about whether or not medical providers could reopen. There was a lot of surgeries that were being delayed because they were trying to save space for the COVID wave that was supposed to be forthcoming. We did a good job of flattening the curve. That wave never came, and we sued and said, okay, it's time to open up the hospitals and let people get their gallbladder surgeries, their hernia surgeries, have people go in and find out, get cancer screenings and these kinds of things to protect their lives through the use of ordinary medical care. The governor changed an executive order in response to that. In the response to our suit, it was supposed to have a federal hearing on one day, and then a day later she said, okay, well, we're going to change all of the rules about medical providers. She didn't change everything, however. She left obviously some conditions that can go on in workplaces, and we're looking at the question of, as of April 30th, when under the 1976 law, her power to declare an emergency ended, and the legislature would have to therefore approve it, whether that meant that any executive order after that date was illegal and void. And that question is one of the two that's been sent over to the Michigan Supreme Court in one of our cases. And so there is we haven't announced that yet. Actually, you all are getting it. It's going to be sending out a press release after we have this session that we are having right here. And so hopefully the Michigan Supreme Court will take it. Now, they did not take an earlier case that was sent up by the Michigan legislature, potentially in part because they were concerned about whether or not those parties had what's a very technical legal term known as standing to bring the suit, whether or not the legislature itself, as opposed to all of 10 million of Michigan citizens, were being harmed by the governor's action. So there are that suit is one of the important ones out of about the 20-something that you identified. We have another one related to when the governor tried to enhance the penalties. A bunch of people were starting to essentially engage in civil disobedience, perhaps opening up their barber shops or things of that nature. And right now the punishment was a misdemeanor. That's what's in both statute. It says that violation of any of these executive orders is a misdemeanor, which is a penalty of 90 days in jail and $500 max. So those are both max. The governor tried to change those penalties so that she would say that any violation of my executive orders is a violation of my OSHA, and my OSHA has a $70,000 an incident and potential up to 3-year felony provisions in it. And so we challenged that in court, and the Court of Claims, which is a state court, held that that was illegal. So that's another one of the big cases. There is a case that the Department of Justice has intervened in related to this. That's over in the Western District of Michigan. So those are 3 or 4 of the bigger cases that are out there. Are 2 cases, one that's before the Michigan Supreme Court, one that deals with the enhanced penalties, the one that the Attorney General has intervened in, and then the legislature suit, which the Supreme Court did not take immediately and sent back to the Court of Appeals. But those were the 4 cases that I would consider the most important. And again, I think that the court that will end up deciding these issues is going to be the Michigan Supreme Court.
Okay, thank you. So in about 10 minutes, we'll try to shift over to answering some of the questions that are coming in. As a reminder, you can type in a question in the chat box, and we will try to get to as many of them as we can. Mike Van Beek, I want to go back to you and ask you another question about emergency powers laws. I know that you've dug deeply into the development of these laws in Michigan and some of the history that led to those laws being adopted. What have you seen in other states, and how do other states differ from Michigan? And perhaps in what ways could we emulate other states if we were to make any changes to our emergency powers law?
Yeah, from what I can tell so far, looking at other states, is some states have similar issues to Michigan, where there is some conflict between the executive power and the legislative power. So Pennsylvania is the most recent example of where this has occurred, where the governor wants to extend the declared emergency, and the legislature is saying that it has to have a say in whether or not that gets extended or not. So that's a very similar situation. Wisconsin obviously also had a conflict over how their emergency power laws worked as well. But in other states, it's been interesting looking at what they have done, because other states have similar laws to the 1976 Act that we have in Michigan, because as I said, that act came out of a sort of a federal program that encouraged states to adopt these kinds of statutes, and were really sort of a formality to allow federal resources and state resources to be coordinated in the case of emergencies. So a lot of states have similar laws to the 1976 Act. But in response to COVID, across the board, it's all over the place in terms of what governors have decided to do and what kinds of powers they've decided to use. So some governors have not, to my knowledge, made use of the type of executive orders that Governor Whitmer has used, or that other governors have used as well, executive orders that have the force of law. Some governors have simply made declarations which don't have the force of law, are not enforced by law enforcement, but are more viewed as simply recommendations for the public. So there is a wide range of processes that have been used to deal with COVID, and Governor Whitmer's particular process seems to be unique amongst the states.
Patrick, I want to ask you another question about the state of the law, and really the question that occurs to me is what kinds of legal fixes might be necessary to address either the conflict between the two statutes, the 45 law and the 76 law, and then what kinds of decisions do you think would give us good guidance for how governors in the future might use our emergency powers laws? We know that there will be new emergencies down the road. I think we can all concede that governors ought to be able to move quickly in certain circumstances, and so we anticipate having these kinds of laws available to future governors, or even this one in the future. But what kinds of legal fixes would you anticipate?
Well, part of it's going to depend, of course, on how the Michigan Supreme Court interprets the laws. I mean, we're in the process of fighting this. I I wish that the process had gone a little bit faster and that the Supreme Court would have weighed in, given the importance of the issues and how long we've been here. I think that the guiding principle should be this. We do need to have something where we can respond quickly for a period of time. I would say a limited period of time. And then after we get past where we have to, just for efficiency's sakes, have a quick decision made, then when it becomes a extremely important question as opposed to an emergent question, that's when we would kick back in and have the typical protections that are put in place by the separation of powers. While it may be a while before we can accomplish this, one thing that I would like to see is if we need to have legislation, if we want the legislature more involved in the process, and I do, I think that in emergent situations we should make it that they can make laws faster. Right now there is a constitutional prohibition that all laws have to sit for 5 days in chambers before they could be passed. And if we are in a spot where we wanted, let's say, to make some of the governor's executive orders the law, as opposed to, let's say, getting rid of some of the licensing requirement or things that are preventing people from coming in to help and to engage in this action quickly, we can do that, but the legislature has to go through a fairly long process. Well, maybe we want to eliminate in emergencies that typical thing that is meant to allow the public to see the laws, to make sure that they're happy with them before they get voted upon, because we need to respond to an immediate crisis. So those are the main principles that I would be concerned with. We do need to have something, and the real question is who gets to turn the emergency off? And that's the problem that's vexing us here, because the 76 law is very clear on how it gets extended and who turns it off. And the 45 law is extremely vague on that problem. So sooner or later, we're going to have to either modify or clarify the 45 law and say the emergency is off and all of these powers now dissipate and go back to our normal process.
Good, thanks. Mike Van Beek, I want to ask you a similar question. Patrick talked about guiding principles that would influence the contours of emergency powers in Michigan. What are some other guiding principles or features of the ideal emergency power law that come to mind for you?
Well, things that I think should be considered are protections potentially about public disclosure of information. So the governor used executive orders to make it, to restrict basically access to government information through the Freedom of Information Act. So that could be a right of citizens that should be protected even in instances of emergencies. The other thing that I think should be considered is and this was, it wasn't just the governor who made this kind of determination, but this idea of deeming certain activities as essential and other activities as non-essential, as if there is some master list of things, of some hierarchy of master needs that we all have. This is folly in my view, and what's essential for me is not essential for you, and vice versa. So I think there might be some need to have a system where the risk to public safety is the only element that can be considered when making decisions about restricting individuals' ability to earn a living or conduct themselves in public in some way. If those things are legitimate threats to the public health, then there is a justification for curtailing them. But any system that determines in kind of an arbitrary way what is essential and not essential, which is a subjective question which is innately a subjective question. That system doesn't work, I don't think, and really doesn't provide the public with the kind of safeguards that we need in these kinds of situations.
Okay, thanks. Well, now we're going to shift gears a little bit, and I'll stop asking the questions. I'll instead ask your questions. And so if you don't, or if you do have a question and you'd like to have it addressed, feel free to type it into the chat box, and we'll get to as many of those as we can. I'm going to start with a question from Rich Weber. And Patrick, this may be best directed at you. The question is, the judicial system supported the governor's use of the 45 law over the 76 law. What was the reasoning for that decision?
Sure. The decision was a decision by Judge Stevens, who's on the Michigan Court of Claims. And essentially it was this is what the text of the statute says. As I noted earlier, the 76 Act is a little bit better written in that it has both a start point and an end point. And it is very clear who gets to turn off emergencies. It's a little bit clearer as to who gets to start emergencies. The 45 Act doesn't have that. So then the judge is left with the job of determining, okay, is there enough here to guide the executive and for the courts to interpret? And this is a question of what's known as delegation. If there is enough here to interpret, then we still have to make this statute work. And what Judge Stevens found was, yes, there was enough here. It wasn't completely decided who gets to challenge when an emergency is over, whether or not it's the legislature or whether or not it's individual citizens that are affected by this. But because of the ambiguity that was written in the 45 Act, particularly it not having a termination point, that is the law that the judge said that the governor could continue to enact executive orders on, because under the 76 Act, the legislature has turned the emergency off. And we are now, as I mentioned earlier, as a question of, are we in an emergency, or is this just an extremely important matter? And according to the legislature, we're past emergency and into extremely important. And according to the governor, we're still in an emergency.
We've got a question from Barb, and I think this might be referring to a case related to a barber from Owasso. So I'll read this, and Patrick, maybe you're the best one to answer this. The question from Barb is, how was the governor allowed to weaponize professional licensing? So can you talk about that case?
Sure. The licensing, I mean, this is inherent in all licensing, is that it is the power to destroy if you don't have a license. We often talk about the power to tax as the power to destroy. Licensing is very similar in that if you can't have your license, then you can't operate your business. About, I think, 21% of our businesses in Michigan require some sort of license at this point. And so what happened is that the governor said that violation of a health code is something that can cost you your license. And because Mr. Menke was repeatedly saying, I'm going to keep my business open despite requests to shut it down, the governor went after his license. The Supreme Court had the trial court had said, okay, great, but you can't take his license yet. The Court of Appeals said, oh, yes, you can. And then the Supreme Court vacated that ruling, and so it's now gone back to the Michigan Court of Appeals for more deliberation by that court as to whether or not they can go after his license.
We've got a question from George Nastis. It's on the issue of the First Amendment and the Second Amendment. And so, Mike, I first want to direct this at you. The question is it legal for a state governor to restrict the free exercise of First and Second Amendments, such as attending church or shopping at a firearms store? And Mike, if you could just address whether or not the governor's executive orders got into those matters at all in your research, and then we'll have Patrick address the constitutional question.
Sure. Well, yes, the governor's executive orders did restrict certain things that could be sold at certain types of stores, and then also obviously restricting gatherings of a certain number, restrict the ability for people to worship together religiously if they choose. Now, the governor's orders also provided an exemption from enforcement for people who chose to gather for religious reasons. So this allows me to highlight a shortcoming, I think, of the executive orders of the governor's process, which is she mandates certain things and then exempts them from enforcement. So I would prefer a system where the governor is simply recommending things rather than saying these things are illegal, you shouldn't do them, but we're not going to enforce them anyway. So it leaves citizens in a situation where they have to choose to do something that the governor says is illegal, and that's a situation I don't think that political leaders should put citizens in. So those orders did address some of those issues, and it's like many other issues related to this. The water was murky, and it was always kind of a gray area about whether or not these kinds of things were legal and whether or not they were going to be strictly enforced by the governor or not.
So on the constitutionality question, obviously there's both a free exercise and a Second Amendment are both explicit federal constitutional rights. What most people don't know is that if you provide a state interest that is sufficiently strong, in certain circumstances you can even suspend some of these constitutional rights. Now, there's a 1905 case called Jacobson involving immunizations that were going on in Massachusetts, so whether or not somebody could be forced to accept a shot. And so there is some Supreme Court precedent out there that says that the state's interest in preventing a pandemic is sufficient to supersede some constitutional rights, at least in the short term. So there is obviously express constitutional rights that are involved. There is very rare that you can overcome and have a state interest that is sufficiently strong, but particularly where we were concerned that we were talking about 200,000 deaths in Michigan, which was some of the scarier initial estimates, then that kind of state interest is probably going to be sufficient to keep people from going to church. As we have gotten closer, gotten further evidence over the last couple, 3 months, we're now at, I think we're at 5,500 deaths, and the number of new cases is definitely slowing down. The argument, the state interest argument of that we have to do this in order to prevent the pandemic from spreading gets weaker and weaker. So this is, the state interest is somewhat dependent upon what we do and don't know, how concerning the emergency is, and this is a lot of the stuff that's being litigated right now.
We have a question from William Brown. I'll ask either one of you to weigh in on this. And the question is, will the individual legislators continue to allow the governor to take the blame for any future apparently unconstitutional lockdowns while failing to go on the record as opposing them? Now, I will say we can't speak for individual legislators, so I might just reframe the question slightly. And the question would be this, gentlemen, what has been the most recent legislative action in reaction to the governor's orders, and are there additional leverage points that they can bring to bear on the emergency orders?
Well, I do know of one that an indication that they were concerned, and that is, of course, the authorization to file the lawsuits. They did vote on that. As to future things, I would think that it's going to come back to how much stomach the legislature has to fight the governor via budgetary matters. There is obviously, we're going to have a very contentious budget cycle that is going to deal with, I think the number I've heard recently was $3 billion shortchange. And so there's going to be a lot of contentious questions that go into that. Politics being politics, I don't think that the budget is going to exist separately from the COVID response. I think those are all going to get intermingled. And I expect that a lot of this stuff is going to be addressed and come into the budget conflict that's likely to occur between the legislature and the governor.
Yeah, and I'll just add, the legislature is obviously, as a group declared, as a majority at least, declared an interest in repealing the 1945 Act and saying that the 1976 Act is sufficient to deal with these kinds of situations. I think that's been kind of the stance that they've taken. But the governor has been very clear that any attempt to strip her powers is irresponsible and foolish. So she has made it very clear that she is going to oppose any reform to these emergency laws whatsoever. And so in that sense, the legislature is limited to what they can do.
Okay, a question from Gregory, and Patrick, we'll toss this one to you. Do some of these lawsuits become moot after the governor eases restrictions on the state?
Some of them have been dismissed after the governor did certain in various things. I would say that there's probably 15 to 20 of them that are still very active in dealing with things that are direct. I mean, the problem is, of course, the governor is in, I think, phase 4 of what he considers a phase 6 process. And so you still have 2 more phases until we're no longer micromanaging 10 million people's day-to-day existence. So the idea that we're going to run out of conflicts about what can and can't be done until the emergency is no longer in effect, I think is probably unlikely. Until we get a clear decision from the Michigan Supreme Court, I expect that we are going to continue to have many legal battles as to what is and is not proper under the governor's emergency manager powers.
Another question related to litigation, Patrick. Do any of the current cases expose the state to punitive or monetary damages? And if so, what effect does that have on the state budget?
Yeah, I haven't looked at all 20-something of them in detail. There is some difficulty in getting, you can't sue a state directly for monetary damages, but you can sue people in their official capacity, and typically the state will pay for them. Under state law, you can only sue the state for damages under certain circumstances, and those are generally related to gross negligence. So most of the cases, it would have to be a takings case. And that's going to be the interesting question, is whether somebody can say, hey, you shut my business down for 3 months. I couldn't earn any income, and you were doing that in order to protect other people, perhaps me, perhaps the citizens at large. Should I get any money for it? I think that it will be difficult for any court, be it federal or state, to say that every business that was shut down is going to be compensated just because of the size of the award. You're talking, every business in Michigan. Are we going to give GM 3 months worth of profits? Are we going to do that for a pizza shop that's next door to our office? I have some difficulty believing that any court is going to be willing to do it, and that there is some difficulties doctrinally as to undertakings law as to whether or not this would be sufficient to trigger monetary awards.
We've got a couple questions from people who are asking about the underlying scientific or fact-based justification for for a declaration of emergency. And I wonder, Mike, if you could address some of the challenges that you have looked into in terms of validating the science and the data that the governor is relying upon to get to some easing off of the restrictions. And then how does that affect the way we think about future declarations of emergency?
Yeah, it's a great question and a real concern, and probably another area that we need to think about potentially for adding an element to a future Emergency Power Act. Maybe there should be some sort of defined threshold of when an emergency can be declared. So the criticism I have of Governor Whitmer and her justification for the crises that we're currently in is it hasn't been well articulated, clear, or well defined at all. The emergency was declared when the state first had 2 positive cases of coronavirus, and then we had this narrative sort of gradually morph and shift over time about what the purpose of the emergency was. So at first it was, we've got 2 positive cases, and then we were supposed to be protecting the healthcare system from being overrun, and eventually it became a much larger target of protecting economic harms for people and just avoiding all sort of any sort of ramification from COVID. So that is a fundamental problem with the way that the governor has decided to go about this, is that there isn't a clear understanding, and she hasn't been forthright with explaining why this certain measures are needed, other than referring back to her earlier emergency declarations as if those were proof of the need for further action. And in my mind, that's insufficient. And the public, I think, should have access to a lot more information.
So, Patrick, related to that, there's also a couple of questions about what sort of emergencies could we anticipate being declared in the future. For instance, unfortunately, COVID-19 has affected a lot of families, and a number of people have died, very unfortunately. But there are many causes of death at any given time, whether it's heart disease or car accidents or discharges of weapons. Any number of things that do result in a large number of deaths on any given annual basis. So what are the protections that we would hope to see to prevent other declarations of emergency to go after other kinds of economic or civil activity?
Well, I mean, I'll put the scary situation out there first, because you asked what can we see this in. Let's just take two issues that are very important to political parties. Let's take gun control for the Democrats and abortion for Republicans. Okay, we can declare both of those to be an emergency. These are things that are extremely important, that death is involved, and then if the situation is the same, that a governor claims, I have unlimited power, largely unlimited power, to work on these until such time as I believe that they have been solved, then you can see some of the difficulties of the path that we have set out in here. And so in the future, I think we're probably going to have to, let me take one step back. I believe the number of emergencies that we've declared under the 1976 Act, we're at 100 and something emergencies. And so you can see that these things, emergency declarations, are fairly common. Well, now we know that they are extremely powerful. And the concern is going to be, okay, now another politician, having seen the first politician do this, how likely are they to say, oh, this is awful, I shouldn't do this? no politician likes having to negotiate with other people. They're there. They believe that they have good ideas and that they're acting for the best interest of their citizens or an important subset of citizens. And so we're going to need to do something to clarify what can constitute an emergency. Not just an extremely important issue, but maybe one that we just have to get control of extremely fast. So, here in Midland, we had the floods recently. Well, that was an emergency for a couple of days. We didn't have a lot of time to sit around and debate and talk about legislation as to what needed to and what didn't need to be done. If you want to talk about the pandemic when it first showed up, perhaps that was an emergency. But extremely important social issues like let's look around what's going on with this right now here in Michigan and throughout the country. There's a lot of talk about racial justice. Some people would say that that's an emergency. So are we now going to have a governor that can declare we're in a racial justice emergency and claim all kinds of powers in order to enact and legislation and or executive orders that deals with it? So I think we really have to tighten down as to what constitutes an emergency. Again, how we turn it on and how we turn it off, so that it serves our purpose of an immediate, quick action needed for a dangerous situation, and doesn't become an unlimited power grab for the executive.
Yeah, and let me just add on to it. There is a certain element where it's enticing to declare any problem that you want to really focus on as an emergency. So, for instance, Dr. Caldoun, who's the state's chief medical officer, just last year, she told the media that vaping amongst high schoolers was a public health emergency. And in her view, it was a very serious problem. But is it a public health emergency? I don't think so, and I think we should have stricter definitions and limits on what qualifies for public emergencies and public health crises.
Okay, good. Well, gentlemen, thank you. I want to thank Joe and Patrick and Mike for your comments and your expertise. Very, very fascinating information. Really appreciate it. Thank you to all of the attendees who were able to watch this program and ask questions. We appreciate it. It elicited some good conversation. And a couple of housekeeping items as we wrap up. If you weren't able to watch this entire program, we will have it on our website, and you can share it with friends and family. It'll be up on the Mackinac Center website. It's mackinac.org, and there's a tab for events. You can click on that, and you'll see a video recording of this program that we just had. There's also upcoming programs that you might be interested in. We typically do a lot of events throughout the year, many of them in Lansing, always dealing with matters of public policy and public concern. But like the rest of the world, most of our events these days are virtual, which is easier for you to watch and not have to get in your car and drive somewhere and get parking. It's easy to catch something over a quick hour. So I encourage you to look at our upcoming events. And then finally, the Mackinac Center is supported by very generous people all around the country, in fact, all around the world. And we appreciate your support. If you're a supporter of the Mackinac Center, thank you. We do appreciate it. And if you're interested in joining the Mackinac Center, you can go to our website, mackinac.org, and click on the donate button and learn a whole lot more about the organization. So with that, gentlemen, thank you for your time. Thank you for everyone who participated in this, and we wish you a good day.